Good afternoon, everyone. Um, we are ready to continue with the second session for today. Thank you for your indulgence during our lunch break. My understanding is that we are going to hear from Equal Education Law Centre. Up next, Ms. Tigofatsa Pahla. Ms. Pahla, if you can indicate whether you are here.
Afternoon, everybody.
Hi, Tigo.
Hi. I've got a presentation to share. I just wanted to check if I'm able to share it.
No problem. I think whilst you're
Dr.
busy...
Carter, can I be assisted with sharing a presentation, please?
All right. Are you possibly able to send it to us per email, and then we can also share it from our side if that's going to be
Yes,
easier for you?
I've done so. It should have arrived now.
Okay. Zuki, colleagues, if you can just have a look for the
I've
presentation.
sent it to Brendan.
Okay. Okay. We'll share it in 1 second, Ms. Butler. Just maybe as an...
You've gone on mute.
That's right. Thank you so much. I think maybe just as an introduction, as I don't think you were here the first session, thank you so much for joining us. We really appreciate your participation, and we know Equal Education Law Centre has done a lot of work in respect of discrimination and societal issues which affects access to basic education. So we really appreciate your time. The session is recorded, and the session is chaired by Commissioner Andre Gam, who is sitting here next to me. Once the presentation is finished, we will be asking questions just for clarity, and then we will release you. But we really appreciate your participation. Let me just check with colleagues. Kenneth, are you? Okay, one
Thank
more
you very
minute.
much, Dr. Carter, and good afternoon, Commissioner Gom, fellow panelists and colleagues, and thank you very much for inviting us to what we believe is quite an important discussion, which is quite a well overdue one. So we welcome the South African Human Rights Commission taking the lead on this discussion, and we look forward to making submissions.
Thank you, ma'am. We're asking, the technical team is asking for 1 more second in terms of sharing the document. So if you can just give us 1 minute, then we will, once we share the document, Ms. Butler, you are welcome to proceed. So just 1 minute.
Many thanks.
There we go. Yeah. The floor is yours, Ms. Basha. Thank you so much.
Thank you so much, and sincerest apologies. I'm the one who caused that delay by sending the presentation a bit too late. As I said, Commissioner Gom, Dr. Carter, and colleagues, the ELC welcomes the opportunity to make these submissions. The Equal Education Law Centre is a public interest litigation organisation here in South Africa. We are based in Khayelitsha in Cape Town. However, we have a national reach. We use the law and various tools in order to try and achieve equal and quality education in South Africa. Amongst some of the tools which we use is public interest litigation, strategic litigation. We do quite a bit of research, and on top of that, we also do a lot of advocacy and legal empowerment of schooling communities in order to try and improve the state of education in South Africa. Crucially, however, and quite pertinent for this inquiry, is that as part of our work, we run a daily walk-in clinic where we provide legal assistance daily and throughout the country to various education stakeholders, including parents, teachers, learners, members of SGBs, and the like. And through our work as the ELC, we've been able to see quite vividly the impact of discrimination in South Africa, the impact of discriminatory uniform policies, which are not necessarily inclusive. And through our work, we've also particularly seen the impact of discrimination on LGBTI learners, and we've seen a lacuna both in our legislative and policy framework of policies and laws which are able to address the issues of LGBTI learners. If you'll excuse me, because I'm partially sighted, in order to assist me to see my slides and to read my presentation, I'm going to switch my camera on and off just to help me. And so I hope the slides will be able to help us. So as I said, as part of our work, we run a daily walk-in clinics, and a lot of the time parents approach us in instances of discrimination and violence on the basis of culture, religion, disability, and in particular sexual orientation and gender orientation expression. As the ELC, we therefore have first-hand knowledge of the discriminatory conduct and prejudice towards LGBTI learners, which pervades the schooling system. We also have seen the impact of this discrimination on learners, and from our work and through research, it's been clear to us that in many instances, intolerances in schooling communities and prejudice fuel high levels of bullying and hate-based violence and speech in the schooling system. Due to discrimination, LGBTI learners often experience reduced school attendance, early school dropout, poorer academic performance, and negative impacts on their mental and physical health and their right to education. We therefore think and believe that convenings such as these are crucially important for LGBTI learners and their right to the basic education, which is contained in Section 29 of our Constitution. According to a 2016 Love Not Hate report, 56% of LGBTI South Africans surveyed said they'd experienced discrimination based on their sexuality or gender identity while attending school. The report found that schools in 3 provinces in particular displayed higher than average levels of discrimination against LGBTI students. And interestingly, for this inquiry, these were KwaZulu-Natal, which had 79% of respondents responding in the affirmative, Eastern Cape, which had a percentage of 70% of the respondents confirming in the affirmative, and Western Cape, with 68% of the respondents saying that they had experienced discrimination based on their sexuality and gender in schools. If you could go to, thank you so much, if you could go to the 3rd slide, please. Thank you so much. So those are the findings from the Love Not Hate Not report, which I spoke to. Gender equality in schools needs to include the acknowledgement of gender diversity and fluidity, and the recognition that all persons, irrespective of how they identify, have the right to equal and full enjoyment of all rights and freedoms, not in particular, obviously, the right to education, which our courts and internationally has been recognized as an enabling right. if we could go to the next slide, please. In starting this conversation and in looking at the legal and policy framework, we think it's important to start with our Constitution. And many of the speakers today have spoken about our Constitution and spoken about the rights, the intersecting rights which are in our Constitution, which are pertinent for this discussion on uniforms. The right to equality, the right to privacy, the right to dignity, and the right to freedom of expression. And all these rights are cornerstones of our Constitution, which is a transformative Constitution, and a Constitution which sought to transform our society, not just outside of our societies, but also inside of our schooling systems, which we think is something which in many respects hasn't been done in South Africa. In order to try and realize this transformative this transformative desire which our Constitution sought to have, the South African Schools Act was enacted. And the South African Schools Act was in a backdrop of a country where our school spaces were highly discriminatory places, where there wasn't enough equality within our Constitution. And the South African Schools Act was brought into force in 1996 with one of its key aims articulated in its preamble to redress past injustices in education provision and to combat all forms of unfair discrimination and intolerance. And I just wanted to note some of the important provisions in the South African Schools Act which are applicable for this inquiry on school uniforms. And the first one is Section 5.1 of the South African Schools Act, which says that all schools must admit learners and serve their educational needs without unfairly discriminating against them. So that's the first purpose of education. It's important in this backdrop that we keep in the back of our minds, what is the purpose of schools and what are our children supposed to be gaining at schools? The South African Schools Act then goes on in Section 8 to deal with school codes of conduct. And really, the purpose of school codes of conduct is to regulate our schooling, to regulate our schools. And Section 8.2 of the South African Schools Act tells us that the purpose of schools codes of conduct is to provide discipline, purposeful school environments, and improvement in quality of learning processes. I think it's important that we keep at the back of our minds these three needs of what school codes of conduct were meant for, or what the South African Schools Act envisaged school code of conducts to do. Because in many instances, a lot of schools use their school code of conduct in order to regulate school uniform within their schooling systems. If we can go to the next slide, please. So despite the Constitution and despite the ideals which the South African Schools Act sought to bring for us, and the purpose of what school policies and codes of conduct were supposed to be, through our work as the ELC, we've seen that many schools in South Africa still have oppressive and stifling uniform policies, which often leave little to no room for learners' gender expression and self-determination. We also wanted to note that this is not so just for LGBTI learners, but equally for cisgender learners. And so really we feel that in looking at the current school uniform policies and their binary nature, it should be borne in mind that they don't just affect LGBTI learners, but that they also affect the freedom of expression, freedom of gender fluidity of cis-normative or cisgender learners. And that's very important for us to also keep in mind. So, as I said, the South African Schools Act provides that schools must govern their uniform policies through their code of conduct. I think it's important then that we look at what should be in these school code of conducts and what does SASA say to us. So the first thing is that school code of conducts must comply with the Constitution. So while Section 9.10 of the Schools Act gives the responsibility and power to make policies and code of conducts, gives this power to school governing bodies, this power must be within the confines of our Constitution. It's also important to note that the minister is responsible for providing guidance to schools in order to guide them on how their school code of conduct should be. And as we know, and as many panelists have told us today, in relation to uniforms, this has been done through a draft policy which was gazetted and published in 2016. Whilst this policy was published not in 2016, in 2006, whilst this policy was published as a draft in 2006, many civil society organizations and stakeholders made submissions on the draft, including the ELC. It's noteworthy and quite disappointing that since then, the Department of Education has not published a final version of this policy. And though in all respects, it still remains a draft. It's also concerning that it still remains simply a guideline. And so that also weakens the nature of this guideline, and that's something that we wanted to note. So there's this draft that was published in 2006. Many panelists here have spoken about it, and I'll also speak a bit about our concerns and our thoughts about that guideline. If we can go to the next slide, please. I'm now going to go through the national guidelines on school uniform and what stands out for us, which we think the Commission should look at and should take consideration for in this inquiry. So at the beginning, the guidelines in line with SASA speak about the purpose of the guidelines being to ensure that practices related to school uniforms do not impede access to education in any manner and do not infringe on any constitutional rights. So the guideline starts with this preface, starts with this aim. Yet our concern is that the guideline does not in fact actually do that, and that the guideline in fact in and of itself is problematic, and in and of itself creates misunderstandings in schools and leads to practices which we feel are discriminatory, particularly for transgender learners, for LGBTI learners, and also for cisgender learners. The policy in line with SASA recognizes the role of school uniforms for social and educational purposes, but says that uniforms in schools should only be retained by those who choose to do so. So that's important. The guideline doesn't say that all schools must have uniforms. It says that those who choose to have uniforms must do so. And we've had other panelists today speak about the importance of school uniforms. Many people, particularly in the human rights arena, have said that uniforms are an equalizer in some ways, because uniforms, for example, protect those learners who are not able to come dressed in a Nike or able to compete with some of the competing issues which come into schools. We've also had some people, however, speak about the rising cost of uniforms and what the Competition Commission has done around there. So around the purpose of school uniforms, I'm not going to go into that, but we've all heard the debate of why we should have school uniforms. Having agreed that school uniforms serve a certain purpose, it's important, however, that we're sure that the policies and codes of conduct we have in schools still meet constitutional muster. So they should not impede on access to education on infringed constitutional right. What's important, again, that we've noted in the policy is the policy says that no child may be refused admission to school based on uniform. However, the policy does go on to say that a refusal to wear school uniform may be treated as a disciplinary matter. We think that this is an important provision of the guidelines to note, because through our work, we have seen how often LGBTI learners, cisgendered learners are put through disciplinary processes in instances where they do not comply with backward policies. And so whilst the guideline says that learners must be included, says that learners shouldn't be denied admission because they don't wear the school uniform policies, we've seen in many instances having, for example, lesbian learners who come to us at the ELC saying that they are not comfortable wearing dresses or skirts, that they want to wear pants, and these learners are then put through disciplinary proceedings proceedings where their privacy and their dignity is infringed on, where they are forced to, in some instances, out themselves, where these learners were not necessarily out about their sexuality. We've seen it, for example, even play itself out in religion with having a Muslim learner say that she's not comfortable to wear a skirt because the skirt is too short and she feels that the skirt does not protect her enough, and wanting to wear pants and having this being questioned, having the way in which she chooses to express her religion being questioned, and then also being taken for a disciplinary hearing. And so we wanted to just note that because disciplinary hearings, we believe, are being abused in the schooling system in order to stifle the freedom of expression of LGBTI learners, and in a way then to make a lot of these learners then be forced to wear uniforms which do not make them comfortable. And these are the sort of things that lead to high dropout rates, lead to reduced outcomes for these learners. And so we thought that that's something quite important. That's quite important to note. We also wanted to note that the guidelines, oh, if we can go back, please, thank you. Sorry for that. That the guidelines state that the range of school uniforms should reflect a South African identity. Now, in order for school uniforms to reflect a South African identity, we argue that they ought to be reflective of the different genders in South Africa, reflective of diversity, reflective of diverse sexual orientations. And so that's quite important. And so we think that the national guidelines on school uniform, I'll be them in draft format, even as they currently stand, do not meet constitutional muster and are not capable of protecting learners and creating inclusive school spaces. Of particular concern to us is also the binary nature of school uniforms, which is created by the policy, which has already been touched on by some panelists here today. So in a particular section of the policy, it seeks to give the school community examples of the form of uniforms which they can prescribe for their school. The problem with these examples, however, is that they're tabulated in the table. On one side of the table, it says boys. On one side of the table, it says girls. And so it introduces in schools the idea that regulating school uniforms should be in a binary manner. The draft guidelines have also caused problems when trying to approach schools through our work on behalf of learners, trying to urge that they have non-binary school uniform policies. A lot of the schools then point us to the draft guidelines and say, well, this is what the DBE has endorsed, and so this is perfectly fine, and we are not going to change that. And so, in a way, practically, the draft guidelines also cause problems for us in advocacy and cause problems for learners who try to advocate for themselves within the schooling system. So the uniform choices provided generally conform with established gender clothing norms and provide little room for gender diverse expression. And so that's what we wanted to point out and quite our concerns. We believe that there's a need for a push to have these guidelines finally published, but published in a form which is inclusive and a form which is through a rights-based perspective. Practices that relate to uniforms should not impede the right to access to education or impede on the constitutional right to freedom of expression, privacy, and dignity. But despite this, in the absence of proper guidelines, many school guidelines or codes of conduct maintain and reinforce heterosis normativity. We can go to the next slide, thank you. In conclusion, on the uniform guidelines, we submit that substantial work needs to be done in amending the current uniform guidelines and providing schools with more inclusive guidance on how to ensure that all learners are protected. I also just wanted to share there two quotes from two seminal cases in South Africa, which with regards to children. And the first one was the Pillay case, which dealt with the right to religion and culture. And that case said to us that school policies that have the effect of discriminating against learners are unlawful and limit a learner's right to basic education. It is therefore important for all schools to ensure that admission policies and code of conduct do not unlawfully discriminate against LGBTI learners. The latter part is, of course, my addition, as the case was not about LGBTI learners. But this case is quite important in supporting the idea that uniform policies which do not include or are not mindful of LGBTI learners and of diversity of gender, even for cisgendered learners, are problematic and discriminatory. I also wanted to also just focus on Teddy Bear Clinic case, which spoke about dignity of children. And it told us that dignity recognizes the inherent worth of all individuals, including children, as members of our society, as well as the value of the choices they make. It is no, and that's important. We think that's important because often these discussions and often thinking around policies at schools really come from a point of view of the adult, a point of view of the parents and what the children's parents say. And very often we found that little recognition gets taken of children and their rights and their right to dignity and their freedom of expression and the need to protect their rights as rights holders. Next slide, please. The last thing which we'd like to touch on is the need for a national policy addressing sexual orientation and gender identity in schools. We'd like to note that there's currently no national policy in South Africa which deals with these issues. And we believe through our work we've seen the need for such a policy in order to guide our schooling communities. Through our work and through research which has been done, it's clear that the problems faced by LGBTI learners are numerous and complex, and that the legislative and regulatory framework has not enabled sexual and gender diverse learners to fully enjoy their right to basic education. Given the high number of cases of discrimination which persist within schools, there's an urgent need for a document that can provide school communities with authoritative direction on how to consider and address questions which may arise relating to gender identity and sexual orientation. Very often, we're approached by SGBs or schools who come to us as the ELC and say, we acknowledge diversity, we acknowledge inclusivity and want to include the learners in our schools, but a lot of these schools are seeking guidance. A lot of school communities have questions. A lot of school communities within a society in South Africa, which is very transphobic, very homophobic, a lot of these schools communities have to face backlash from parents who are anti-change. And so in many instances, in the absence of a binding guideline or policy, many of these schools find themselves unable to respond in a meaningful manner. More importantly, we recognize the importance of a document to deal with these questions with sufficient consideration, nuance, and sensitivity. Learners, teachers, management, and governing bodies should also be trained on the principles of gender and sexual diversity. Often, without even starting on these issues on uniform, you find teachers who don't even know what it means to be transgender, teachers who continue to misgender learners or think that a lesbian woman or lesbian learner is a transgender learner. And so it's important in thinking around uniform policies that these sort of changes also be supported by training and education of our educators. It's clear from the interactions which we continue to have with school communities that they feel highly unsupported in respect of the inclusion of LGBTI learners. We'd like to note that there have been two drafts or two attempts at providing this support to schools. On a national level, we're aware that the Department of Basic Education for some years now has been in the process of drafting a national guideline on Sahrc issues. We're concerned, however, that year in and year out as civil society, we get told that the document will get published, but it doesn't get published. So, for example, at the end of last year, we got told that a national policy would be published. We're sitting on March, and it's unclear when we can receive a policy. In relation to the Western Cape, for example, the Western Cape Provincial Education Department must, of course, be praised, because they, as a province, took a step in order to publish a provincial policy, Sahrc policy, in 2019. Despite that progressive move, we've seen the policy in draft form move from being a policy to merely being a guideline, and remaining in draft format since 2019 and not being published, similarly to a national policy. During the course of last year, we were told that it would get published at the end of 2021. In questions from the media this year, we've seen the Western Cape Education Department say that it will only be published at the end of this year. And so that's a whole year shift in when they said it will be published. And our concerns with the policies or the drafts that we have seen is that they, in as much as we welcome the moves and attempts at drafting policies, is that they're entirely problematic, in that they fail to address questions relating to sexual orientation and gender identity with adequate sensitivity and reflection. The documents which we've seen and which we as the ELC have commented on, in many instances, are riddled with highly concerning and problematic language and terminology, inappropriate use of binary terms. So we've seen the insistence on the use of he and she, and a failure to use pronouns such as they in order to be inclusive. And in many instances, a lot of the drafts we've seen have been unclear and vague in places. And we are concerned that that would render these documents ineffective for learners, even if they're published. In a lot of instances, documents use very soft language. So in a lot of instances, they use words like recommends and not must and not shall. And it's very loose. And so as a loose document, we're concerned that the document fails to be forthright in protecting the rights of learners with learners, LGBTI learners, and affirming their rights. We're also concerned by the lack of a rights-based approach. So, for example, with the Western Cape policy, there's nowhere in the policy where it speaks about rights, or even mentions the words rights, or even mentions any of the rights which are applicable to this issue, which are in our constitution. And so that remains a big concern for us. There's accordingly an urgent need, we believe, at the Equal Education Law Centre for national, comprehensive and rights-based policy on sexual orientation and gender identity in schools. Next slide, please. We believe that until we have such a policy, until we have such a policy, schooling communities and learners will really be left without any protection and any guidance. We accept that in many instances, these are challenging discussions for school communities to have, and that school communities face a lot of pressure from the community around them in trying to be inclusive and try and change. I've shared there with you, though, we are hopeful, though, and we've seen in many schools that change can in fact happen and that inclusivity can in fact happen. I've shared with you there two articles which are quite recent, but particularly for the Western Cape. In the one school, for example, we had a school allow learners to wear badges with their pronouns alongside their uniform as part of being inclusive. In another school, we had, and there the article or the headline of the article is problematic because it speaks to boys, whereas this matter was about a transgender female learner, and so it should read girls or transgender female, but also where a school allowed a learner to wear a dress in instances where that learner wanted to wear a dress and identified as female. I think what's also important at looking at uniforms is that one shouldn't just couple or put together the LGBTI community as one globular group, which is often what's done. And one needs to realize that sometimes the needs of transgender learners are very different to the needs of gay or lesbian learners. So we shouldn't mix up sexual orientation and gender identity. And we need to realize in approaching uniform policies and their amendment or transformation that we should equally address their varying needs and the different protections which they need. A transgender female learner, for example, may still want to wear a dress as part of their gender identity and part of their expression. A transgender male learner may want to wear pants as part of affirmation and expression of their gender identity. Equally, a cisgendered female learner may want to wear pants as part of their expression and how they feel like they have dignity and how they express their gender in schooling communities. And so it's very important in making the suggestions that we make in transforming uniform policies that we're cognizant of different identities, cognizant of different expressions. Um, yeah, so thank you very much for this opportunity. We'd like to thank the Commission for having us. Thank you so much.
Thank you so much. Just Thank you so much, Ms. Pashlav. That was very informative. I'm going to hand you over to Commissioner Gam for the first round of questions and comments.
Yes, thank you very much and good afternoon. Thank you for a very comprehensive and excellent presentation. Yes, I'm thinking uh, of the Western Cape Education Department coming out and saying that they're about to publish their policy when we had the Work School Strand matter. And this is the first time I actually hear that they've decided to actually postpone it until the end of the year, and one wonders why exactly that is and what the reasons were that they were providing. What one is even wondering even if they don't regard this whole matter as too controversial or whatever the case may be to come up with that policy. And then the end of the year might even be postponed even longer. So I would think that maybe even we consider as part of this particular inquiry to also write to the MEC, Western Cape MEC for Education, to find out why it is that this policy publication has indeed been postponed, and to urge her to publish it as soon as possible, because clearly this is something that can't wait. If we have a look at how long we've waited for the national department to publish something, we're still waiting. So yeah, I think we should actually, from our side, apply the necessary pressure as far as these issues are concerned. The way that the Worskell Strand matter eventually panned out was actually also one of the positive outcomes that you can include on your list, because yes, although unfortunately the learner was excluded from that school for some time, at least after we've also intervened there, that school has indeed amended their policy within a week. So I think that's quite a positive one that one can also take forward from that perspective. But I just wanted to make the point that I think we should apply pressure both on national and the Western Cape Education Department, to finalize their drafts. Thank you so much.
Thank you very much, Commissioner Gomes. I think that would be quite helpful, and I think civil society is quite concerned because letters to the Office of MEC asking when the guidelines will be published have gone unanswered. Yet in the media, we've seen the end of the year. Whilst we're concerned that it's moved from being a policy to a guideline, be that as it may, I think even if it's published as a guideline, that will be very helpful to schooling communities.
Thank you, Ms. Butler. I think I have a few questions, more to garner your views or your comments on them. Your presentation was very helpful as it zoned into the guidelines specifically. And my question to you is, or more maybe a comment, is that we are still sitting with a concern that these guidelines are not binding. It seems like they are mere suggestions to SGBs on how they can best proceed forward with what I think is being deemed as almost a school by school case. Now, do you think, in your view, that we need a policy rather in respect of the school uniform concerns that you've pointed out? I mean, you were very clear to say, as it stands, the guidelines is not going to pass constitutional muster, and that is what we've heard here this morning from various stakeholders. So that's my first question. Do you think we need something more binding as opposed to guidelines which appears, is not being implemented appropriately, or the suggestions are not progressive enough? And even if they are, schools will still decide whether they follow them or not. That's number one. Then number two, I'd like to ask your views whether you think the guidelines in terms of uniform also is broad enough, or has potential to be broad enough to address and prevent hair discrimination. So we are aware of very express laws and legislation coming from the states, and whether you think one should adopt that approach, or possibly it's already being addressed by PAPUDA. We just need to have a stronger implementation, possibly, of the existing laws. So the second one would be hair discrimination. And then the third one would just be your views on how all of this and your experiences with the learners affected, because you were also very clear to say that the well-being of learners are definitely being adversely affected when they have to focus on access to education, but now they need to fight about, whether they wear a skirt or pants, and it affects their well-being. So how do you see what we're talking about playing out in the private education and independent schooling system? And what do you suggest do we do superimposing this conversation onto that platform? So those are my three comments or questions. Thank you so much.
Thanks so much, Dr. Carter. I'll start at the end. You asked about PAPUDA and whether I feel PAPUDA in any case addresses all of these. And I think everything we've spoken about PAPUDA addresses. I think everything we've spoken about our constitution addresses. But I do think in a society and in a context where we see discrimination happening, where we see something being systemic and a pervasive issue, then that's when we actually need to give communities, and in this instance, schooling communities, guidance in order to bring life to the Constitution and in order to make the Constitution real. So in those instances where we see repeated issues, where we see that it's a problem, and we've seen in media articles, we've seen from the work that we do, that uniform issues around hair, those issues are a problem in our communities. Our schooling communities require guidance and policies. And so in those instances, in order to make our Constitution real and give it teeth, as it were, it calls on us as part of the constitutional, you know, what's it called? I didn't have the word earlier, but part of the constitutional, the work we have ahead of us to do those policies. In relation to guidelines versus policies, I really do think that this is such an important and big issue that it warrants a policy. The Department of Education has many guidelines dealing on many things. And when you simply make this issue a guideline, you're pretty much saying, well, in this big basket of lots of things, we're just popping this in, and it's a must be nice to see, and if you want to see it. I mean, I give an example of the Department of Education's anti-homophobic and bullying policy, which if you go on their website, you can't even find, and it's not published on their website because it's a plethora of guidelines, things to help you on some things which might make your life easier. But the reality is the issue of LGBTI learners is not about making people's lives easier. It's about rights, and it's about these children's rights which are being infringed on a daily basis. And we cannot continue to allow this to be put as an issue of it's hard conversations or it's difficult, particularly with the kind of research which we have. You know, the research which shows us that discrimination is happening on a daily basis. When you know that if I identify as a certain gender, wearing gender which confirms with the gender which I identify with is not a nice to have, it's part and crucial to my right. And so we've called on saying that these documents need to be policies because policies are stronger, they have better teeth, particularly on such a difficult topic. If we are saying that it's difficult for schooling communities, then we do believe it needs to be a policy in order to make it stronger. We know that schools, I mean, with us school principals, we often have very progressive school principals who face a lot of backlash and a lot of opposition within their schooling communities. And merely giving them a guideline doesn't help them with that. They need policies in order to also give them teeth. I'm abusing the notion, but to give them teeth in what they're doing. And so we really think, and we continue to urge that it must be a policy and not a guideline. There's also a need to look, as I said, at the wording. It can't be the soft, very soft wording. At the end of the day, these documents need to come from a rights-based approach. And a rights-based approach, if we do that, I would like to propose, would actually make the work of the provincial education departments or the Department of Education much easier. I think the problem right now is they're trying to make a policy which isn't framed within rights and which isn't framed with, and so that makes it harder, I think, for them, which I think is the problem with the current drafts. Um, the last question which you asked, I just wanted to remind myself about it, was about the learners that are affected. Through our work, we've seen that for the learners that are affected, how these cases usually come up and show up for us is either A, the learners facing disciplinary proceedings because the learner is, for example, a transgender girl. We recently had a case of a girl in Khayelitsha, a transgender girl who had her hair long. And she got told that she could not come back to school until she had cut her hair because she's in fact a boy, she was told, and she's transgressing the school uniform policy. And the school followed the disciplinary proceedings to a T. They didn't they didn't go against their own policies. They followed them to a T. But this meant that this learner was away from school, had a tension around their gender identity at school, and everybody knew about it, had to come and defend themselves in disciplinary proceedings. Had it not been that that learner had a quite compassionate neighbor who knew about us, that learner was about to just give up and cut her hair, or even worse, leave school. It also led to their parent knowing about it because their parent got called in, and we know that this child got hit at home quite severely because of this. And so we need to understand that for transgender learners who this is part and parcel of their very being, this hits at something quite important for them. It's not just a nice to have, or I just want long hair because I think it's cool. Um, and so those learners, as I said, one of the things is they face disciplinary proceedings. They miss school time because of that. Many of them give up because they think, they've got choices to make. Either I live a dignified life at school without being bullied, without being teased or violated. And so a lot of them then just keep quiet if they're not supported. Or some of them do come to us, but the fights are such long fights where we're going backwards and forwards with SGBs that we've actually seen a lot of the learners give up and say they're not going to do this. It's also hard for us to bring a lot of these cases to equality courts because often learners who are LGBTI rights, often their parents don't know, often are scared of being victimized and bullied. They don't have support.
Just the last comment, Ms. Patla, the independent schools or private schools element. How do you see us, or how do you see us superimposing this whole experience, and what is your view on that?
Than public schools, and one can impose a little bit less or be a little bit less prescriptive to private schools than we are in public schools. But our constitutional court has been quite clear, for example, in cases like the Pridwin case, that the Constitution also applies to private schools and that our private schools are not above the Constitution. And so, again, I keep saying that I think that for these matters to be easy, we need to approach them through a rights-based approach. The question should be, is the policy or the way that their action infringing against a right? And if it is, then they're not above that simply because of their independence. And I think the Constitution should be our guiding, compass in looking at each of those on a case by case basis.
Perfect. Thank you so much. That's it from my side. Mr. Mpondu, over to you.
Good day, ma'am. My question is on the point that you made about the Western Cape policy. I heard you say it is not a rights-based approach, whereas it was drafted in 2019. And my question is, does it also have the similar loopholes as the national policy, like in terms of appearance, gender barriers, and extra? Thank you.
The Western Cape policy is slightly more progressive on uniform, but we do still have concerns around use language such as recommends, may, must, and so we're worried that it then doesn't make them as strong. But it does, and it still gives a binary and then gives choice, but we do think it is a little bit more progressive.
I have one or two questions. Yes, the first one is that, yeah, you've referred to some of the matters that you are dealing with in respect of certain learners in schools that take a very long time. So I just want to make use of the opportunity, maybe, for greater cooperation between the Equal Education Law Center and the Commission. As you might be aware, these days we're not only issuing recommendations and so on, but also directives. And in the case of the Hoërskool Strand that I mentioned, our intervention had a quick result in the sense that even that Afrikaans-speaking school amended their policy within a week for their code of conduct. So I just want to extend that uh, invitation for cooperation. Second thing is that I think one of the problems, even with departments like the National Department and the Western Cape Education Department, and many other people in this country, is that they think this the so-called well, let's say the LGBTI plus issue is a side issue, that it is not core business, and they treat it like that. Also, uh, indicative of that is, the fact that these are simply guidelines and things like that, and that it takes so long to complete and to get published because it's treated as a side issue. And I think hopefully out of this inquiry might come, to make it very clear to all that this is not a side issue. As you indicated quite clearly, that it goes to the very being of people, of children, and that therefore this way of treating these issues as side issues should come to an abrupt end. The third point I want to make, and maybe have your comment on, is that one sees that some private schools take decisions or adopt codes of conduct and so on based on religious considerations, and then attempt to rely on the religious rights in the constitution. Now, would you agree with, maybe it's quite a general statement in a sense, but I have come to firmly be of the view that you cannot exercise your religious rights in terms of the constitution in a way that cuts into Section 9, the equality rights. Would you agree with that point of departure? Thank you.
Thanks for that, Commissioner Gordon. Firstly, thank you very much for the invitation that we should work more closely with the South African Human Rights Commission and reach out to your office in instances where violations are brought to our attention. And I welcome that. And I do think it's something, a mechanism which we as the ELC should use much more and that we don't necessarily use as well as we could. So thank you very much for that invitation. In relation to your comment about LGBTI rights being seen as an extra or something else, I agree with you. Often, I know a lot of academics sometimes say we shouldn't even call them LGBTI rights because LGBTI rights are not, it's not a set of rights written somewhere which only are applicable to the community, but actually, even internationally, you've had international commissions and international bodies refuse to give a set of rights because they've said that all other rights are universal. And so the right to equality, dignity, and all the rest apply to LGBTI persons. And so we don't need a set of extra rights, which is what has been said, which is why, for example, I've said that the policies which are published should really just lay on and reinforce the rights which exist and should be applied. In relation to the right to religion, I agree with you, and I think it's the old age saying, which maybe seem very basic, but is so true, is that my rights begin where your rights end. Firstly, but also that in terms of Section 9, I think that it would be much harder for one to, and I cannot see how one could limit the right in Section 9 merely for the right to religion. And I do think that is where the right to religion cannot necessarily overstep the right to equality. But that also said, the right to religion is the right for one to practice their religion, etc. And I cannot see how the rights of LGBTI people, i.e., their right to equality, their right to dignity, can reasonably said to be infringed in order or limited in order for someone to enjoy their right to religion. And so I can't see how the two can coexist or be together. And so I agree with that idea. Thank you.
Thank you so much, Ms. Butler. I think we've come to the end of your submission and our questions accordingly. It's been very valuable, and I do think you bring home just us remembering and recognizing again that we have a finite number of years in which we are able to respond to the needs of these kids with dignity. Whereafter they're out of the system. They are no longer children, they are no longer in school, and lingering and postponing the implementation of rights, acknowledgement, which is inherent to these children. We're going to miss them. They're going to exit the system without us having treated them with the dignity that they have been awarded simply for being. So I think there is a need for urgency and a need for recognition that any policy or guideline, and I don't even want to say guideline because you've correctly pointed out, we have 200 guidelines, and at the end of the day, it's not implemented, and it is also done so on a case-by-case basis, whether the schools want to or not. And I do think that we need to drive home the urgency of any policy or any legislation that affects the rights of children. They are children for a finite number of years, whereas they are gone, and they will have to carry the effects of the non acknowledgement of their dignity, their equality rights, their rights to self expression for the rest of their lives. So I really appreciate your presentation, especially like I've mentioned earlier, zoning into the guidelines specifically, because that gives us a great footing to say that possibly one of the directives that the commissioner will be making out of this is to say that can we afford guidelines when it has to do with children, whereas we cannot allow for years and years and years to go past, was it 2005, um, uh, the first attempt. Those children have left the system. They've left. They're adults now. They're no longer affected even by the policies that we are thumb sucking um, through each generation. And we really need to bring home the urgency of any legislation and policy that affects children, especially when they are school going and when we have a level of responsibility towards them, in terms of the Constitution at least. So that's just my parting comment to you. I look forward to working with you further and just for us to strengthening this relationship and to see where we will take the rights of children, especially within the LGBTIQ community as well, forward. So thank you very much.
Many thanks.
Thank you very much.
Um, Okay, good afternoon, everyone. I think we have come to the end of today's proceedings. The participant who was scheduled for this afternoon will just engage with one-on-one to make sure that we do hear from Kula Community Development Project possibly tomorrow. However, I think it's prudent for us to wrap up this afternoon so that we can at least prepare for tomorrow's proceedings as well. So from my side, in terms of just a quick thanking everyone, all the participants today. I think we've been provided with valuable information and valuable perspectives, both from a legal point of view, from an education point of view, from the well-being of the child's point of view, the Commission for Gender Equality, and it's really been a good platform for us to work from. So, Commissioner, if there's any parting comments from your side, or can we wrap up today?
No, thank you very much, Provincial Manager. I think we can wrap up. Thank you very much for everyone's participation, and also for those who joined us online. The inquiry is continuing tomorrow morning at 8 and also on Wednesday, so we hope to see all of you again, and even more people that would follow these important proceedings on these important matters. Thank you.
Commissioner, we have been joined by the participant.
Oh,
If you are okay, then we can
yeah,
proceed.
yes, no,
Mr. Mpondo, would you like to chair the session or would you like me to continue? All right. Good afternoon, Mr. Majola. Are you there? Mr. Majola?
Yes.
Oh, there we are. Good afternoon, sir. Welcome to this inquiry. Are you well?
I am not 100% well. I'm not actually winning with the signal.
Would you prefer for
Yeah,
us, Mr. Majola, would you prefer for us maybe to postpone your submission to tomorrow?
that would be great. That would be great for me.
Okay,
I'll be in a better signal
okay.
tomorrow.
Thank you, Mr. Majola. We're going to wrap up now and then we'll engage you outside of this meeting. Thank you so much. So
Thank
we
you.
are wrapping up as per Commissioner's directives and we will see you tomorrow morning. Thank you. Bye-bye.